courts and to make provision for matters connected therewith, we now read a second time. Member for Oropouche East.
Thank you very much, Madam Speaker, and thank you for the opportunity to contribute on the matter before us this afternoon. Madam Speaker, the matter before us appears to be a short, non-contentious matter of introducing courts, processes, providing for administrative structures to support new institutional developments. But, Madam Speaker, I begin by stating that it is not as simple as it may appear. And while the Attorney General is very convinced on the path that he has led us here this afternoon, there's a difference between being convinced and being convincing. And the Attorney General is, of course, understandably very excited by piloting this measure. And maybe it's because of that excitement that he may have been easily distracted. But I would like to take a few minutes at the beginning to, like the Attorney General, reflect on the context within which this matter is heard and this bill is being brought to the House. Madam Speaker, I agree with the Attorney General on one matter and one matter alone, that the number one issue facing this country is crime. It is, by a long way, the most significant challenge, problem, dilemma, burden that the citizens of Trinidad and Tobago carry at this time. We have never lived in such troubling times of insecurity, of apparent hopelessness, of cluelessness, of fear. Madam Speaker, we all live in a society today where we are under a self-imposed state of emergency, where families do not come out. When they come out, they are in mortal fear as to their children returning home. In Palmy, San Fernando, I believe, a few nights ago, a couple came home in the evening, relatively early at around 9-10 p.m., to be held up by gun-wielding, cutlass-wielding bandits, their car stolen at gunpoint. Thankfully, no injury to the persons. So, Madam Speaker, I will not join the Attorney General to recite statistics on crime. In fact, I think to recite statistics on crime is becoming an embarrassment. The country knows the state we're living in. Everyone. Businessmen tell you their safest moment is when they clear Trinidad and Tobago airspace. That's when they feel safe. And they can relax and walk around and enjoy, the streets of another country. Because you cannot enjoy here. We don't know where we are going. And it is getting worse. And it is coming home to roost. It is coming home. So, Madam Speaker, I will not get into the statistics. But the Attorney General did ask an interesting question. He said, what happened between 2010 and 2015? What happened? But I'll tell you what happened. The now talkative member for Moruga Tableland. I would tell you what happened. We had the lowest rate of serious crimes in 50 years. Murder was going down, not going up. Anytime you turn, you see police, patrols, security. If it was not the Trinidad and Tobago Police Service, it was the Citizen Comfort Unit. An elderly lady in Diego Martin reported that Citizen Comfort Patrol assisted her in the night when the police could not reach to her defense in a matter. That is what happened in 2010 to 2015. While we did have crime, and we did have to manage that, the member for Siparia and national security ministers and others could have been seen on the street in joint patrols. Anytime we instituted something, the Prime Minister and the relevant ministers would be on the street leading. And not just leading, ensuring that the security forces were doing their jobs. That's where we were in 2010 and 15. Where we are today is a very difficult place. And the Attorney General may even mean well. He may even mean well to bring these matters to us today. But, Madam Speaker, I will make some headlines first before I get into the text. And the headline news for me is, why are you spinning top in mud? Yes. Why? I think persons understand the problems we face with the justice system. Since the Prescott report of 1990 or thereabout, we have had reports upon reports, commission of inquiry and this and that. We all know the problems. In a matter that I know about in the magistrate court, the matter was called 27 times before it being dismissed. Someone accused the defendant had to go to court 24 days, 27 days, missed work, abandoned taking children to school 27 times over a 3-year period or so for the matter to be dismissed. There's a problem we face. And I asked the Attorney General, would anything that you are proposing in this business here before us help to deal with that? Would it help to deal with that? And we must take a dose of reality. Reality is like a chemical composition. You must drink some, swallow it, digest it, understand where you are. And I will begin with a few items of reality. We are all aware, many of us on this side, many, if not all, have been in government before, some more than once. We are aware of the role of the judiciary, the role of the executive, and the role of Parliament. I want to remind the Attorney General and others, and in preparing for this matter, Madam Speaker, we had the benefit of speaking to those practitioners in the High Court, to speak to those persons who are employed. We had the benefit of getting some research materials and so on elsewhere. And I asked the Attorney General, and he may have the answer, but I asked, because I didn't hear in the initial contribution, to what extent was consultation with relevant stakeholders undertaken? And stakeholders that may have included the judiciary, the magistrate, the clerks of the peace in different districts, the Criminal Bar Association, the Law Association, the Assembly of Southern Lawyers. Did you consult with stakeholders? Now, if the answer is yes, you'll tell us, and you'll tell us the benefit of that consultation. But we did not hear it in the initial 45 minutes. Now, Madam Speaker, the Attorney General agrees with me that passing legislation is not all. That will solve nothing by itself. You know what's the problem we face today, Madam Speaker? And it is quite instructive that the Attorney General, in a nice way, he reminded us that building courts is not building court. It was quite instructive because when we think of building courts, because the Attorney General said they were building courts, I asked my colleague along this line, I said, what court they build? Then he corrected himself. He said, we didn't build anything, but we outfit buildings. And I believe there's a building in Faizabad, outfitted for a court. And publicly linked to an official of the government. Publicly linked to an official of the government. There's a question now as to family and children division of a court in Sinclair, Port of Spain. Is that also linked to a high government official? Is that also? So is the approach, rent buildings from government official, call it court, and we build court? That cannot be the approach. Courts, Madam Speaker, I submit the judiciary courts, those institutions and so on, as far as possible, we should try to construct independent buildings and property owned by the government, owned by the people. Why do you spend $500,000 a month in rent for buildings? While if you take that money multiplied by 3 years, you could build an entire building. And you could build for less than $29 million that they are spending on a Moruga youth facility. You could build with a few $1 million, you could build courts. Undisputed land. I think they're stealing somebody's land to put at $29 million. But I'm not going there. Madam
Deputy Speaker,
let me continue
I
without
rise
going there.
on standing order 48-6.
He started.
Thank you very much.
Member for Oropouche East, I'm sure with your experience you can use a much more parliamentary term. Could you kindly just withdraw that particular term? And
Madam
sure
Speaker, I withdraw
you can do
that. I was
with ease
already
and
in
continue.
flight on another issue. Madam Speaker, I want to remind the Attorney General that at the Hall of Justice today, the air conditioning has been down for more than a month. that judges have been forced to move matters to San Fernando Supreme Court or adjourn matters. It was brought to the attention of the authorities in the judiciary. They are claiming that they don't have money to fix the air condition at present, so there's no solution in sight. It has affected the delivery of justice. The air condition affects the delivery of justice. Today, you want to set up a whole new structure and institution. The public toilets in the Hall of Justice are not working. So if you go to the Hall of Justice, you have to go in Woodford Square or somewhere else to use the public toilet. These are the real matters we face as a crisis. What was the court administrator and the deputy executive court administrator going to do that? Fix the toilet? These are the real problems. Because of a lack of planning in setting up the children's court, staff from the judiciary are being poached to provide support for the children's court today. There are judges now who face problems because their staff are leaving and they are without the critical staff as secretaries, judicial support officers, orderlies. So you are poaching away from the mainstream judiciary. Judges and their teams are operating without critical and basic necessity such as paper, toner, ink for printers, stationery, toilet paper. There was a memo from the Ministry of Education. They couldn't provide coffee and tea. Then somebody, Department of Government, Northwest Regional Health Authority, said they couldn't, that on one ground floor, people were using too much toilet paper or something like that. This is the state we are in. So I'm coming back to the judiciary. These are the problems they face. The staff of the High Court are demotivated because of a lack of payment of traveling allowances, jacket allowance, acting, gratuity payments, and so on. People have been waiting years for their payments of gratuity and allowances.
Madam
Speaker, may I ask
you to look at Standing Order 48.1, please? I think it's
very relevant. This is very relevant to the discussion about the bill. Stick to your policy now. Is the question of justice.
Please continue.
Thank you very much, Madam Speaker. Madam Speaker, let me continue to speak of the crisis in the judiciary and then match it to the solution being proposed today.
Absolutely.
Or the lack of a solution. Madam Speaker, the San Fernando Magistrate Court is operating on a shift system, like a junior sec. That's how they are operating today. Despite the promise to sort out that problem, the San Fernando Court is being housed, the Magistrate Court is being housed in the High Court building. So High Court matters are stalled or they cannot proceed and so on. Most of the Magistrate Court do not have electronic recording devices, such as notes of evidence. Notes of evidence is still taking years to produce. The Family Court, which the member for San Fernando West raised as a big point of success and so on, as the most successful project, they do not have an operational library for more than 4 years now. So when you examine this bill and what it seeks to do, it seeks to create more positions, more layers of bureaucracy. It is job for the boys and job for the girls. On contract, and I'm coming to the nature of this in a few minutes. So they are going to create jobs for the boys, jobs for the girls by doing this. So how are we going to look at this business here today now? Let's go to the bill, because I know the member for St. Joseph really wants me to get into clause by clause. So I'll do that. There's no problem with that. We're quite prepared for that approach as well. You see, Madam Speaker, we deal with traffic issues now. That's what we do with traffic offenses, which is what the bill deals with in a fundamental sense. That it appears that way. This is a government that has a preoccupation with traffic offenses and traffic management. Maybe in another incarnation, those on the other side may have been traffic cops, or what's called traffic wardens on the road with a bright fluorescent vest or something. But they're preoccupied with that. Since arriving into office, we have had this unbelievable approach on the streets, where more and more police hiding in the bushes with little gadgets and stopping the motor cars, charging them. They're in Katwaru Trace and Pinal, stopping the people down there. They're by Gulf City and the main link road there. Because instead of 50 km, you might be at 55. And they then pounce upon you. And by their own admission, they are now saying that revenue raising from traffic offenses is a major source of revenue for this country. So, you could rob a jewelry shop on High Street, break the glass at 12 midday, injure the people. But God forbid if you try to drive 5 km more than the limit in San Fernando. You're in trouble, huh? You're in trouble. The problem they have is the murderers do not speed and they don't drive drunk. That's the problem. Because that's their fascination with traffic offenses. You should have a fascination and a zeal to deal with murder. That is what you should be dealing with murder. And this government should have looked seriously at a recommendation that came from a parliamentary JSC, Committee of Parliament, Madam Speaker, where at a particular meeting dealing with an inquiry into criminal case flow management in the judicial system, Friday, March 18, 2016, and this was the Joint Select Committee on Finance and Legal Affairs. I'm waiting for St. Joseph to tell me 48-1. Madam Speaker, at this meeting, where the Director of Public Prosecutions and others appeared, they recommended, Madam Speaker, certain matters, establishment of specialized courts as a means of improving the rate for the dispensation of criminal matters. Specialized courts may include remand court, gun court, drug court, murder court, full stop. I didn't see traffic court. I didn't see, but you will, I did not see.
The member for Oropouche East. Usually I don't have problems in hearing him, but I'm getting a little difficulty. Please continue.
Thank you, ma'am. I was in mortal fear you were going to say, usually I don't want to hear him. But Madam Speaker, the JSC recommended a murder court, first and foremost, not a civil division of the High Court and the traffic offences division in the lower court. A murder court, if you want to speak to us about that. It is murder that is terrifying and brutalizing the society. It is not the traffic offence that you stop all over in the countryside and picking up people and making money. It is not that. And this is a recommendation from the Parliament Joint Select Committee. So, is the government saying that the criminal division of the High Court, to be so named, is a murder court? No, it can't be. It cannot. Well then change the name then. Call it murder court. So we'll do it that way. You see, Madam Speaker, this bill, if it was to see the light of day, should really have received greater attention. And, I don't want to preempt anything because it is a lightweight kind of bill. And maybe the government could have asked if they wanted that it go to a joint select committee and let's sit down and work it out and see what better could be done. Because better must be done. It cannot be a question of renaming someone from a magistrate, name a judge, someone from the clerk of the peace, name a something else. This is about renaming people and hiring more people. Let's go to some specific issues here. Section 3. I'm looking at section 3, ma'am. 2G. A clerk of the peace shall be read and construed as a reference to a magistracy registrar or clerk of the court. So we change the name. Good. You come down here now to some. It is a muddled piece of legislation. It is muddled. It is confusing. It is convoluted. And I want to give a public administration perspective on this now. Now, at 6.2, you can take information by conducting hearings by telephone, video conference, and other appropriate electronic means. Just a quick question. Are you going to really conduct a hearing by telephone? I suspect that you mean bail applications or something like that, but you will conduct a criminal hearing by telephone. So, okay, then you will correct, you didn't want to give way to the member for Siparia for a question, but you want to ask 1,000 questions now. Madam Speaker, at 7.2, a puisne judge or master assigned to a criminal court under subsection 1 may apply to the Chief Justice for reassignment to any other court. Now, you're putting into the law an application process, a statutory right of some sort, that a judge can ask the Chief Justice to get out of the criminal court. Now, what is that about? Now, and a fundamental question we want to ask here, and I know the Attorney General and others on that side are intolerant of critical questions. Correct. They're intolerant. When we ask critical questions, we either don't love the national anthem, or we don't love red, white, and black or something like that, or, we are being obstructionists. But they can't understand that if they bring good legislation, we will support it. We supported the anti-gang legislation in the House. I understand they went somewhere and butchered it and slaughtered it and betrayed the trust of the opposition on the anti-gang bill. Madam Speaker, I'll not go there. Let me move on quickly. Madam Speaker, a question that we ask here, a question now, and it is a simple question. If we are wrong in interpreting, the Attorney General will get great pleasure in beating his chest and correcting us. To what extent is this type of law suggesting that a master undertake the role of a judge? Is a master going to be a judge? Now, judges are appointed by the Judicial and Legal Service Commission. But in this matter, you get the sense that the Chief Justice will assign, as he is wont to do, could do, but bring a master into hearing matters in this criminal court. And the master, because there's another part here, which speaks about the privileges, authorities, and so on, of a master. Now, again, don't get vexed because we ask a question, clarify it. And does a master then get the terms and conditions of a judge? Don't get vexed. Don't get vexed. Bring clarity, not vexation. So, I want to make this point in the context of something else. This is a country now where we must all admit we have had, for one reason or another, we have had the judiciary. The judiciary has been dragging through the mud. The image in the judiciary, the confidence in the judiciary has been taking a beating. And that is a matter in the public domain. I'm not speaking to those sordid issues. All I am saying is that the judiciary has been taking a beating. And it could well be that the confidence in the judiciary is at an all-time low. So at the same moment, the confidence is at an all-time low. Instead of using the parliament through our legal and constitutional role to bring accountability, you are giving greater powers to the judiciary. To hire, to fire, that by definition in our system is almost non-accountable. There were renovations done to a building in Faizabad. I understand hundreds of thousands, possibly millions of dollars have been spent to renovate the building of a government official in Faizabad. We cannot ask a question because it was done by the judiciary. They are not accountable. So we should be careful in giving further power to hire, to fire, to spend money when they are not accountable. So the Chief Justice, whoever he or she may be, gets this power to assign to the criminal court persons and to remove them if they request reassignment. What could happen in our system for specific matters? Somebody may have an interest in a particular judge here in a particular criminal matter, and they just trigger here. They say, listen, I need to be reassigned, I need to get out of this. Because we have had a case which I cannot talk about. We have had another case where someone is saying they were forced to resign, and we're not going there as well. So somebody arguing that they're forced to resign, and you put a clause here that that person or any other person, they could ask to be reassigned. And then somebody else comes to hear a critical matter. And that somebody may be a master who is not a judge. This is serious. Then at clause 8, a judge when sitting in the criminal court shall be known as a criminal court judge. Well, how brilliant that could be now. What a touch of legislative magic. So what is the big deal? You call them a criminal court judge or you call them a judge? And then they apply to be reassigned, so they then cease to be a criminal court judge.
So they then become civil court judge.
A master while sitting in the criminal court will be known as a criminal court master. Now you hope it's not a master criminal. A criminal court judge or criminal court master shall, in addition to the powers conferred under the Supreme Court, have all the powers exercisable by a magistrate in criminal matters under the certain act. A criminal court master shall exercise authority and jurisdiction of a judge. So a criminal court master shall exercise all the authority and jurisdiction of a judge, which are conferred upon masters. So, now, and I was, yeah.
It's farcical.
Now, I was reading the parts that I thought were more sensible. I'm now coming to the other parts, which I thought is completely ludicrous. So, you come now to the District Criminal and Traffic Court. You are renaming again. The problem that everybody know, why don't you work with the judiciary to build more courts, to appoint more magistrates, to appoint more judges? Work with them, that is the problem. Madam Speaker, that is the problem that we all know. We all know that years now. Look at something here. One of the problems in our system is the DPP's office. The DPP office. In the ratio of attorneys to criminal matter in the Assizes Court, the following are some statistics that the DPP presented recently. In 2010, 1 attorney to 66 matter. 2012, 1 attorney to 78 matters. 2014, 1 attorney to 84 matters. Did it get better or worse? 2016, did it get better or worse? 1 attorney to 150 matters. 2016. While the acceptable ratio is to have 1 attorney to 25 matters. So why don't we work with the DPP office? Why don't we do, you have, I'm tempted to say you have a house to fix. But you have to fix a problem. Start with the little things that you can do. Fix the air condition. Let's begin there. Fix the public toilets. Then work with the judiciary to hire more staff, to get more buildings, and invest public money on public buildings. Why it is you can find 400 million highway to Toko, 500 million for one terminal in Tobago. That is almost $1 billion gone. Huh? But you cannot secure some funding to build courts and then you outfit it. That is what you do. Now, I mean, you have to open the Children's Hospital. We know that. But the last government put a building called the Children's Hospital in Couva. It's there. I mean, apart from opening it, there are buildings we have built. When we were there, you could look around and see our legacy in infrastructure. You could look around and see our legacy with police stations. I think we completed 9 police stations. 12 we were dealing with in 5 short years. Not one police station you have built. Not one court because you're outfitting. We're coming back to court, madam. So, the district court judge. Now, a magistrate, when sitting in a district criminal and traffic court, shall be known as a district court judge. What is the big deal of this? What is the big deal here? What will that solve? What is it we're solving by calling? Yeah. So, somebody will get a contract to do signage for all these new buildings. Criminal division and traffic court. The new names of the magistrate, the one turned to master, the new names of somebody called a judge. And you have to buy new cutlery, table, chair, glass. And then everything in this country has to be in Spanish too. So, Madam Speaker, you are wasting resources. If the judiciary that spent over $1 million to refurbish a house in Faizabad, a building in Faizabad, today cannot fix the air condition. Work with the judiciary to fix the problems, the small problems. That is the message we give to you. Madam Speaker, the senior magistrate, registrar, and clerk. Now, they are creating, and I heard the Attorney General talk about flattening the structure and so on. I heard this thing of flattening the structure. Now, why? And I'm looking at clause 15 and thereafter. Because I'm looking at 15 to 19 in one. And let me quickly just rattle out this. Now they are going to create senior magistrate, registrar, and clerk of the court. They are going to create a senior person and then a normal registrar. Then they're going to create district criminal quasi court, keeper of the records. They are going to create positions, enormous, positions, because they have now court managers, deputy court managers. You will have here, incidentally, a criminal and traffic court administration. Yes.
Your original 30 minutes are now spent. You're entitled to 15 more minutes if you so wish to avail yourself. Please proceed.
Thank you, ma'am. Madam, they are going to create deputy court executive administrator to head the criminal and traffic court administration. They are then going to create court managers and then deputy court managers to help the court managers. And they're going to continue and continuing. But there are some important issues to raise on these matters. And had this the benefit of the opposition or wider stakeholder consultation, we would not be asking these questions. And we would have sorted out. The court executive administrator, how is that person appointed today? Is that by the Public Service Commission or by the Judiciary? Or the Judicial and Legal Service Commission? We are informed this is the Judicial and Legal Service Commission and the Chief Justice. Now, that person appoints a deputy court administrator to deal with this entire area. And they continue to make appointments, Madam Speaker, but they're saying the person may be a public officer or on contract. Now, you are going to bring in persons who have enormous power in dealing with assigning criminal matters and dealing with the administration here. Assignment of matters, bail applications, and so on. They can seal and unseal. And Madam Speaker, you know the trouble we have been having in the public domain with this matter of sealing and unsealing. Because hypothetically, in Trinidad, we could have a matter where a high government official is involved in a private matter. He or she goes to the court in Trinidad, and because this person is on contract, hired, and instructed by someone else, because the court administrator, whoever he or she is, instructs, that person reports, the term used in the bill is report. Report to the court administrator. That person could be pressured to seal matters. So, contrary to the public interest, we might be sealing matters that involve public officials running afoul, not of the civil code, but of the criminal law as well. So we can have predators in office. We can have criminals, fraudsters, tricksters, hoaxsters. Oh, I can't even pronounce that word. And when you are in contract, it means you could be fired. If you resist a high official, you could get a separation with a non-disclosure agreement. You could find yourself working in the next area as part of a cover-up. That is possible under this bill. Because once you are hiring people on contract, so we begin by saying, deal away with this contract business. Correct. Where persons come on contract and they are exercising such authority. And they are reporting, to someone who by definition is at the whim and fancy of an executive or senior officers. Madam Speaker, and I want to make the link, because they said they are saying here in clause 19 I am on, the deputy court executive administrator is to be given terms and conditions equal to those of a deputy permanent secretary. What? Now, who appoints a deputy permanent secretary? Is it the permanent secretary? A permanent secretary don't appoint a deputy permanent secretary. It's the Public Service Commission. So why don't you go to the Public Service Commission to make these appointments as well? Rather than have a court executive administrator who operates under the Chief Justice. I am linking this thing to show that you are producing a bill for the concentration of power into any Chief Justice. Where we have in the public domain a crisis in confidence in the judiciary. You are going to concentrate power when the judiciary is not accountable, not even to the executive. The executive becomes almost a postman to bring matters to and from cabinet to the judiciary. And you are going to give more power, non-accountable power, This is frightening on financial matters and on dealing with sensitive matters in the criminal jurisdiction.
Who they accountable to?
You have the politicization of this process, where the government or any government in office can use the law to hound down political opponents in and out of parliament, put them before the courts, and then you have people there determining assignment of judges, determining bail, determining other matters who are on contract. Yeah. They could, and given this government's history, they could be on month-to-month contract. Because we have seen this type of thing now, a month-to-month contract. This is madness of the highest order. Madam Speaker, they need to relook the appointments of these senior office holders, and we suggest that you look to the Public Service Commission and nowhere else. Absolutely no issue of contract officers and so on. Madam Speaker, there are also some other matters. The court executive administrator now, and I'm 22 shall assign court managers, assistant court managers to the criminal court and to the district criminal and traffic court. Now this is interesting. I just cite it here as a bit of a inconsistency, because there's a deputy court executive administrator responsible for the criminal court and the traffic court. Right. But yet they give the full power back to the court executive administrator. Because if you already in this bill, your boss is the deputy court executive administrator, why do you then give this power to assign court managers, deputy court managers and so on, or assistant court managers to the higher office rather than the one that has been appointed for this? Madam Speaker, that was a smaller issue to me. In the And you know, at number 5, 22.5, the assistant court managers of the criminal court shall report to the court manager of the criminal court, and the assistant court managers of the district criminal and traffic courts shall report to the court manager of the district criminal and traffic courts. There's no need to put that. In any organization, you have a hierarchy of responsibility and reporting and so on. I don't think you need to put in law that an assistant report to the manager, that type of thing. You see, Madam Speaker, while this may have good intentions, this may really have good intentions, there's a great risk involved here. You know, I want to remind the national community that when the former administration came to the House with a bill called the Constitution Amendment Capital Offences Bill 2011, I have a copy in my hand. When we came to the House with this, the then opposition did not support that bill on several grounds. And one, I remember, they said you don't need this bill for hanging. You could do it within the framework of the existing law. Well, we are about 3 years into their term of office. Anybody face the gallows? How you couldn't do it under the existing law? Huh?
And today he's coming to say what's the promise.
The other major issue here was the categorization of murder. That has root, Madam Speaker, in a report that was done, I have an next copy here in my hand, the death penalty in Trinidad and Tobago, a report on the death penalty, whether it should be retained for offences under the criminal law of Trinidad and Tobago, by the commissioner then I believe was Mr. Elton Prescott and others. 1990, recommended categorizing murder. And in our bill, 2011, we dealt with that. That would have been one approach that you may look at. I am told, Madam Speaker, there are about 750 persons right now awaiting a trial for murder. 750 persons. I wanted to believe when I heard that, I heard wrong. And they are waiting what could be 12 to 15 years without bail. 750 persons. Had we been categorizing murder, some of these people would have been outside given the categories that we are dealing with. That is something that the Attorney General, instead of rejecting when we brought it, could have included. If you want to deal with this system here and you want to address the matter. Madam Speaker, there's some smaller questions just briefly to ask as I get prepared to wind up. In the matter of traffic violations and so on, while we are all aware of what these violations would be, there was a question being raised by some practitioners, Madam Speaker, that whether we are, through this process, is there an intention in the bill to widen the criminality of low-level traffic offences? And to what extent this might be an unwanted consequence of high court criminal traffic offences, of these matters being dealt with at a higher level. Madam Speaker, the offences that we know, driving license-related offences, lighting offences, highway offences, neglect of pedestrian rights, traffic violations, and so on, these are offences that can be dealt with at a lower level. One suggestion that came up years ago that we could have looked at is if you have in the lower court 40,000 traffic offences or so, you could have introduced a system of lay magistrates. The industrial court has that too. Members of the industrial court are persons who are not lawyers or judges and so on. But, they are known as members. Some people call them judges mistakenly. But you could have introduced a system of a tribunal of some sort where you create lay magistrates, retired persons from the public service, school principals, persons who have been in disciplinary environments in the police or the military or so on, defense force, and create tribunals to deal with traffic offences. And you would have gotten thousands and thousands and thousands off the book. You pay your fine, you go. But Madam Speaker, a traffic court today in 2018 is not a traffic court that we talk about 18, 20 years ago. There was a time when we were excited with traffic court. We said, nice man. We saw some show on TV, night court or something. And then we tried to introduce it here and discovered people get robbed in the night here. So, Madam Speaker, traffic court is not a beautiful concept as it was 20 years ago. Today, technology has ruled out traffic courts. You get your fine, your ticket, when you break the light in the night or anywhere, it comes to your phone. And you look at your phone, you see the ticket, and you say, listen, I don't want to pay no more money by going to no court, You pay one time, online. You get your ticket, you pull aside at the side of the road, and you pay your ticket online. The technology is driving a lot of these processes for traffic offense violation and penalties and paying penalties and so on. So we ought in 2018 to really do some more research, policy documents and so on, to see how we can use the technology to reduce this backlog and not to contribute to the backlog. The intention cannot be to have a traffic court and then put the next 40,000 people before the court. That's not the intention. It is to reduce the 40,000. And don't have any more. So look at the technology and see what we can do to make the technology applicable. So people don't have to go to a physical building to pay a fine and so on. That is something we could look at. Madam Speaker, yes, I spoke already about the gun court and the murder court. And the Attorney General could tell us if this is the murder court that he's proposing for us today. And he just didn't name it that. Madam Speaker, the problems in the court, the magistrate court in particular, known to all, the issue, Madam Speaker, for us is not institutional fiddling. It is not establishing more bureaucracy, hiring the boys and girls. Because this takes time. Listen, even if you do this with good intentions and you pass this measure, you're not going to do this. This is not going to be implemented this year, maybe hardly next year. You have to go through a process of hiring people. You have to go through a process of advertisement and recruitment. You have to get buildings for these people where the air condition is working, where facilities are working. You have to do that. So this will not change anything in the short term. It will change absolutely nothing. In the short term, the government ought to get their act together. The government ought to get their act together and work with the judiciary, the DPP office, and continue the good work that was started before. Continue the good work. Now that we have a Minister of Public Administration who is up and about and apparently looking well, now that we have a Minister of Public Administration, work with the judiciary and those departments as the DPP to get places for them or to build out as government property, and don't be in a position where you have these stakeholders coming before Parliament every now and then and begging and crying and bawling and groaning because they don't have toilet paper, they don't have toner for their printer, they don't have chairs and table, and more importantly, they don't have critical staff, which is the problem we face. The problem we face is not a need for greater bureaucracy. It is not for name change. It is really to get precious resources in the specific areas to bring about change. Madam Speaker.